Good morning, ladies and gentlemen. It's a privilege to be here talking to you today and to participate in this event. The risk of prosecution and the risk of significant penalties in a criminal court should never be the main motivator for getting safety right, of course. But for many, particularly those of you that are responsible for the purse strings, understanding what's happening in the legal world, understanding how penalties are changing, can be one powerful motivator to put into the mix. And I'm going to be talking to you today about a very, very significant change in how we punish breaches, certainly in England and Wales as of today, and probably coming to Scotland in the not too distant future. It's been described in my circles as the most significant development in health and safety enforcement for decades. And it's specifically a new document called a definitive guideline for sentencing health and safety breaches. In the 20 minutes or so that I'm going to be talking to you today, I'm going to provide you with an overview of this new definitive guideline to let you see the factors that are determining sentencing as of now in England and Wales, to help you see the factors that really you may want to reflect upon after today to make sure that you are getting things as correct as you can. And I'm going to finish with just a few comments that highlight areas that are prone to non-compliance, even in large, well-run, well-resourced organisations. This new guideline applies to the criminal punishment of all health and safety offences committed by organisations, whether it's a prosecution under the general duties under the Health and Safety at Work Act, whether it's a prosecution under specific regulations such as offshore regulations, construction design and management regulations. It applies to all corporate breaches, public or private organisations. It also applies to the punishment of any individual who in their personal capacity has been convicted of a criminal offence. So it could be, for example, a director who has pleaded guilty or been found guilty of consent, connivance or neglect. If an individual is aware that their organisation is doing something in a deficient manner and specifically authorises that, or fails to demonstrate leadership by challenging those in the organisation that says that that's an acceptable way to operate, or somebody who fails to do their job properly where there are, for example, safety roles and responsibilities that they have, that will be a personal offence and can be punishable with imprisonment. At the other end of the spectrum with employees, it may be as simple as a failure to take reasonable care at work, a failure to look after their own health and safety or the health and safety of those that they work with. The guideline applies to all of them as well. Finally, in passing, I'll just mention that the guideline also applies to corporate homicide in Scotland and to corporate manslaughter in England and Wales. I shan't be troubling you with the numbers for that in any detail. I will mention them only in passing at the right stage. So D-Day for us in England and Wales was the 1st of February of this year. We knew the guideline was coming in for a long time. It was published officially on the 3rd of November of last year. And there has been a mad rush in England and Wales on any case that's going through the system that was about to be charged to get it pushed through as quickly as possible before this guideline took effect. A strategy that didn't always work because it had been published for so long. Judges had read it, and as one judge said to me one day, "Miss Abbas, I cannot unread what I've already read. Your client is getting whacked." There was a big rush, but the damage was already done from the date of publication back in November. It has not yet taken effect in Scotland. It is a document that is specifically confined at the moment to England and Wales. But what we know has happened previously in the Scottish courts is that after a short period of implementation, a decision is made in Scotland that these guidelines are sensible, they contribute to health and safety, they motivate stronger leadership, and therefore they should be applied in this jurisdiction as well. So please don't sit comfortably if you only operate in Scotland or envisage that you could only be before the Scottish courts, because it is coming in the not too distant future. Why do we have it? Why do we need a definitive guideline? Well, simply we need a document that provides independent direction to judges as to how to sentence organisations in particular, also individuals, who get safety wrong. Organisations that might on paper look like they've got good resources, look like they're committed, they've won a few awards, but actually they have allowed significant risk to exist. They maybe have cut corners, or they may simply have not got things right. What tends to happen in the criminal court, and this might sound bizarre to those of you that have been fortunate not to find yourselves in that environment, is that some judges have found so little guidance available to them, they will literally turn to the advocates for both parties, the prosecution and the defence, and they will ask us to tell them what sort of ballpark they should be in. I was recently representing a chemical plant. We'd had a significant explosion, and the judge literally looked at us and said, what should I do? What fine should I impose? And where I'm there representing a company, obviously my duty is to my client, and whilst I can't mislead the court, clearly they're going to want as light a penalty as possible. Similarly, the prosecutor's got a job to do and to raise awareness of the significance of health and safety, society's expectations of those that operate chemical plants, and an individual that perhaps wanted to also please the inspector that they were working for by getting a significant penalty. So we each made our representations to the judge, and the judge said, do you know what, I haven't got a clue what to do. Come back tomorrow afternoon at 2 o'clock. He said he wanted to go and take some advice. I suspect he took it from his wife, from his neighbour, from anyone else in the judge's canteen, brought us back the following day and imposed a fine of £80,000 and said to us, by the way, I place no emphasis on what either of you said, because you clearly both have an agenda. And so this guideline is supposed to stop that sort of nonsensical conversation with lawyers who would find it very difficult to give clear guidance to judges. It's to provide a tariff, a range of penalties that society has said through those writing the guideline is appropriate for getting safety wrong. And we'll look at what the numbers are in a moment. So it's providing that guidance to judges. Similarly, there is a need for increased consistency. As lawyers that practice in the field of health and safety enforcement, we all quickly research once we know which judge has been assigned to the case, whether it's a sheriff, whether it's a judge south of the border, whoever it is. We're all doing our research to see what kind of judge they are and trying to give good advice to our clients as to what to expect. There has been wild inconsistency in different jurisdictions, in different courts. There are particular judges that we keep our fingers firmly crossed we don't get if we're mitigating. The reality is we need some independent guidance to judges so that it's less of a lottery and it's more of a consistent approach to penalising those that have not done enough. Similarly, there's been a call for increased proportionality. What that means is bigger fines for bigger companies, to wake up the people that sit at the top of the company to say, don't be complacent. Don't say because it hasn't happened to us, it's not going to happen. The idea is that the fines that could be imposed are so significant that it generates more interest, and it generates interest from all those on the board and in the senior management teams. Similarly, the objective of the guideline is to better fulfil the purposes of sentencing, and a very important factor in sentencing is deterrence. And you've heard quite a lot today about, are we learning our lessons? And there are many examples of repeat incidents that indicate that industry is not fully absorbing the lessons and implementing them as well as they should do. And in respect of statutory purposes of sentencing, a key one is to deter you from having the same kind of problems again, but also importantly to deter others from making the same mistakes that you have, and thereby encouraging you to have exactly the sort of dialogue that you're having today as an industry to learn from each other. And so the purposes of sentencing are better served if there are big numbers on the end of it. It generates debate and interest from a wider group of people. So let me give you some highlights of this new definitive guideline and how it determines the sentencing exercise. Well, really there are three key headlines. The first is that the judge's task starts with assessing culpability. How badly wrong have you got things? And it will fit into one of four simple categories: very high, high, medium, or low. From looking at the definitions that come in the definitive guideline, it will be extremely difficult to argue on behalf of organisations that they're anything lower than high, for reasons you'll see. The second big decision for a sentencing court is risk of harm. And that will be a number between 1 and 4. 1 is really bad, 4 is not so bad. And the third headline that will determine the level of penalty is there will be a tariff based on your turnover. Not your profit, your turnover. There will be then adjustments made, but the turnover categories are interesting. We have ranging from micro, if your turnover is less than 2 million, up to the most significant, large, if your turnover is more than 50 million. Park your profit, park your warnings for the future. If your turnover is more than 50 million, you'll be in the large category, and that's the category that has it's the highest category that has a table giving us a tariff. But we then have a description of what's termed very large organisations, and that simply means that your turnover is very much more than 50 million. So if your turnover is 10 billion, 20 billion, 5 billion, then you're clearly in the very large category. There's no table for that. It just indicates on the document that if you fit into very large, there is no upper limit for the court to have in its mind, and it may need to impose a much higher penalty than if you fitted just into the large category. I had a recent discussion with a client with a turnover of 90 million. Is that considerably more than 50 million? Probably is in a courtroom. So those are the three things that need to be assessed. You will notice there the word death does not appear. We have moved with this definitive guideline to focus very much on potential, not outcome. And that's one of the huge changes in sentencing. Although over the years we have seen cases where judges have concentrated on potential and HSE have correctly put the potential before the court, we only had a guideline that was relevant if in fact you killed somebody, which we know is often a matter of chance. And so this guideline really takes us away from that. And you'll see in a moment the significance of actual outcome and how small that significance is in the scale of the sentencing exercise. So I said a few moments ago that it would be very difficult to get beneath high. Very high is deliberate breach of the law or a reckless disregard of the law. But high is the very interesting one. High can be determined in two ways. And you only have to tick one of these. You don't have to tick all of them to be categorised as high culpability. If you have fallen far short of the standard, or if you have committed a serious and/or systemic failure to address health and safety risks, you will be in high. In terms of falling far short of the standard, it is often the case, in fact, it's almost always the case, that in prosecutions that is asserted. What we have within this guideline is 4 clear examples of how you will be within high, or how the judge may classify you as within high. And I think that's where it starts to get very interesting. So, for example, if in your organisation you have failed to implement standards that are recognised industry standards for your sector, that gets you within high. If you have received warnings from employees, anonymously or otherwise, or warnings from a health and safety advisor, warnings from an audit exercise, for example, that you ignore. That's not the same as reviewing and determining a different course of action to the one that's suggested. The word ignore is very important there. If you ignore those concerns, if you fail to find the time to look at them and take appropriate action, that will get you within high. If you have had a previous incident and you have failed to learn from it, to prevent a reoccurrence, that will get you within high. And so realistically, HSE inspectors, rightly, during investigations today, are going to be very interested in any previous experiences you've had of a similar kind. And what I find industry is extremely good at is producing a thorough investigation report with a very long action plan. But what you're not so great at is being able to produce the evidence that you measured the success of the action you took, and that you have established those were the right actions because they have in fact prevented a recurrence. Good at the former, not so good at the latter. And that will now get you into the definition of high. And similarly, breaches that are found to have existed over a long period of time, a very subjective term, long. Long could mean 5 years, could mean 1 year, could mean 3 weeks in the context of a specific operation. If it can be shown it has existed for a period of time, that can get you into high. And so again, the way investigations are going to develop, I suspect, understandably, is going to be some real scrutiny as to how long this breach was existing and the opportunities that presented themselves for you to appreciate the problem and sort it out. And the longer the breach has been allowed to continue, the more danger there is. And what we tend to find so often when a breach is established is that actually that's the way the guys have been doing it for a long time. We may say we're going to do it this way, but in fact we're doing it that way. And nobody's been looking to see whether the way we're actually doing things is the way we said we were going to do them, where we'd properly risk assessed it and properly planned it. So I've looked back over everything I can remember of my last 20 years, the cases that I've acted on, and I find it extremely difficult to identify cases falling beneath high. If you had a totally isolated incident, but you were otherwise very good, and you accept guilt, you may get into medium and low, provided none of these other factors exist to aggravate the offence up to high. So there'll be a lot of scrutiny as to how long the problems existed, how you've dealt with any concerns that have come to the surface. Those are going to be areas that rightly the regulator focuses on in due course. And certainly when I'm advising clients, it's areas of focus for us. So let me move on to the second headline of risk of harm. The judge has to come up with a number between 1 and 4. We have a simple chart in the definitive guideline. We go along the top looking at potential. If the activity could have killed somebody, we're not going to get out of A, which means we're never going to be at number 4. And if it's an activity with a high likelihood of harm, for example, work at height, dangerous substances, we're going to be at 1 pretty straightforwardly. If it's an activity that doesn't ever kill or cause permanent injuries, if the worst that could happen is a simple broken leg, for example, and it's something which incredibly rarely leads to harm, then you'll be down at number 4. But think about the industry that you're in, the activities you carry out. Think about the examples of tragedy we've heard today. We're always going to be in that top left-hand corner when we're talking about major hazards. You'll see there that the only context in which the word death is used is in relation to potential on this slide. So we could be at already harm category 1, the top category, simply because there was potential for death. If we weren't already at 1, before the judge makes a final decision as to the harm category, which he needs to decide to then be able to use the tariff properly, there are 2 other considerations for him. So if you're not already at 1, 2 other questions. Did you expose multiple people to the risk of harm? When is the answer to that ever no? it's often the case that many people have been exposed, either because the activity's been done by different people, or it's been done in teams, it's been done for a period of time. It's always going to be, realistically, exposure of multiple people to the danger. And then the judge can take into account, finally, whether there's actual harm as well that's been caused. So this is placing the actual outcome some way down the list for the court in terms of its sentencing exercise, which should in turn reduce the focus in criminal prosecutions on whose fault it is that accident actually occurred in the way that it did on the day it did. Less focus on the actions of the deceased or injured person, more focus on what you have failed to do as the employer, the duty holder, looking at your failures rather than focusing on the eventual incident, that what materialised. So if the judge was not already at 1, he could take these factors into account and push you up a category. So if you were at 2 or 3, you could now find yourself at 1, if in fact there's also harm and perhaps also multiple people exposed, but only one of those is needed to move up. The judge might decide not to move up, but instead to use those factors against you when he's looking at the tariff range that we'll come to. There are many aggravating factors and then mitigating factors that have to be used to adjust the figure. I'm only going to highlight a few of them because of the time constraints today. But specifically as aggravating factors, we have a separation in the definitive guideline of previous convictions and then a poor safety record. And so those that have drafted this document are very clearly telling us that there is a difference quite materially between those two things. And it means that simply because you have no previous convictions doesn't necessarily mean that the court is going to treat you as an exemplary organisation. If in fact you've had a number of near misses, other incidents that didn't lead to prosecution, it could even be incidents that have been outside of this jurisdiction in other parts of your organisation, in different parts of the world, for example. The court could say, well, you may not have previous convictions and you'll get brownie points for that. However, you don't actually have a fantastic record in respect of this activity. And so you'll get some aggravating element there. There are other factors. Cost cutting is also in the guideline, and it's there to capture deliberate savings of money, deliberate cutting of safety to save money. That is very clearly an aggravating feature. There's also some new mitigation points that appear in the guideline. One that's particularly interesting is cooperation. It's always been accepted in the past that if you cooperate with the requests of the HSE, when they want to see witnesses, when they want documents, that will be a significant brownie point. Not anymore. In the definitive guideline, it's very clear that you will only get mitigation brownie points for what's described as a higher level of cooperation than can be expected of a responsible duty holder. And the sorts of situations in which we have seen the court saying that is a higher level of cooperation than can be expected is often, for example, in the situation where a client chooses to waive legal privilege over a warts and all internal report and says to the HSE, there we are, you can see our own findings, we've beaten ourselves up very properly in respect of the investigation, and then the HSE may be able to use that report rather than conduct their own extensive investigations. In that context, I've seen the court say that's a higher level of cooperation than can have been expected. We'll have to wait and see how that pans out in due course, because a responsible duty holder is going to oblige with requests that the HSE make. They're going to make people available and produce documents and share facts with the HSE. But you're going to have to do something more than that to get a specific brownie point for cooperation. And then I think one that's going to become the most important mitigating factor, which is this one. If you can demonstrate that you have effective health and safety management systems, that they are working, that they are robust, but despite those, you have accepted a breach in a more isolated sense, that will be viewed as a significant mitigating factor. And the reason I say that this is, I think, the most significant mitigating factor is because if you can demonstrate how thorough you've been in identifying risk and managing it and making sure that what you're doing on the ground day in, day out is compliant as it should be and people are being kept safe at work, then coming back to those assessments of culpability, you give yourself the best chance of arguing that you're not in high or very high, that actually you're more towards medium and low. But that's a very important one, demonstrable evidence that all is as it should be day in, day out, rather than just negative findings in audit reports that there's a problem here, there's a problem there, actually looking to ask yourselves, is everything as it should be? That evidence would be highly significant. So let me give you some sobering examples of how the guideline works. I'm not going to put all the figures up. If we were to have simply a large organisation, so a turnover of more than 50 million, and it was high culpability, so let's say the breach has existed for a long period of time, let's say some maintenance on a platform has been carried on contrary to a method statement for some years maybe, or certainly months. If we accept that, for example, there's some work at height involved, you're going to be in harm category 1. There's no question that there's a risk of death if anyone's working at height. Let's accept it's high likelihood of harm as such a significant killer. Then what the tariff tells us is that the starting point for the judge is £2.4 million. And it tells us that the range that the judge should be thinking about is 1.5 to 6 million. Now, have there been cases where there have been fines of that magnitude? Yes, of course there have. Really serious cases, often cases with a horrific outcome involving perhaps multiple deaths. There have been cases like that. There have also been some very significant near-miss cases with very high penalties. But generally speaking, that is hugely higher than we have had prior to the 1st of February 2016. Let me go to the other end of the spectrum, but sticking with a large organisation. Let's say it is an isolated failure. You're able to demonstrate that this is totally isolated, but you accept you didn't do enough in respect of the issue that's under scrutiny. But let's say still it's an activity that we accept either could have killed, and it's one of the activities that unfortunately does every now and again kill people, or maybe it wasn't risk of death, it was something less significant than that, but multiple people were exposed, and or somebody was in fact harmed. So much lower down the scale. The starting point the judge should have in his mind, according to the tariff, is £300,000. And the range goes up to £700,000. But if you're very large, forget that £700,000. It could well be that it has to be much higher than that to be proportionate to you as an organisation, which is quite a significant step forward from where we were before. Ordinarily, judges would form a view as to the appropriate fine and then look at your finances to make sure you can pay it. But now they must look at the finances before they even get to the tariff, and that will give them the sort of range. So, for those of you that are thinking these numbers sound daunting, is there wiggle room? Well, there always is. Lawyers will always find it. The reality is that there is a provision, it's called the stand-back provision in the definitive guideline, which says that the judge needs to take into account before reaching the final figure a number of things, particularly whether it is in fact proportionate to impose the penalty that the tariff suggests should be imposed. And I think that's where profit and the impact of the penalty in reality on the organisation, on the workforce, is going to be paramount. And we've already seen in the first few weeks of the new guideline, people going to court being much more transparent about their bleak future and the reality of their finances. Whatever the accounts might say with some creative accountancy, the actual reality is much more bleak. And so we've seen organisations that might normally want to keep that out of the public domain actually using it to avoid multi-million-pound fines. There's also a discount for an early guilty plea, a third off if you promptly enter your plea on an acceptable basis. And also, if the HSE, for example, have chosen to adopt a charging regime where you're charged under multiple regulations, Health and Safety at Work Act, sometimes we see what we call a loaded indictment, but multiple charges over the same event. There is a provision in the document to say you need to look at the totality. You're not going to be imposing multi-million-pound fines on different charges for the same kind of behaviour in the same set of proceedings. You need to stand back, decide the figure and then distribute it as appropriate between the charges. So let me move on to just briefly talk to you about how this is working in practice, because we have now the benefit of a couple of months of the regime working. I want to start with a case where I was acting for the principal contractor in this case, and we didn't get prosecuted, but the subcontractor did. Well-known, large, reputable organisation with an exemplary record on working at height. But on a particular site, on one morning, somebody had removed some handrailing in an area where work at height was going to take place. The contractor, through their supervisor, sent their team to get on with some dismantling work, and an individual working for the subcontractor went over to the area where the handrail had been removed, looked over it and fell. He didn't fall a huge distance, but he did break his leg, if I remember correctly. Anyway, the subcontractor pleaded guilty, was dealt with around the time of the new regime coming in. If that had been dealt with outside of the new definitive guideline, it's probable that the fine would not have been more than £10,000. I did a case in Edinburgh Sheriff's Court just a few days ago. It was the client's third conviction for work at height. It was a more serious injury than this one, and we were fined £6,600. And in England and Wales, that's the sort of penalty I would have expected, say in January or December of last year. They got fined £54,000 on a guilty plea. Syngenta Limited, very large company, inadequate risk assessment in respect of the operation of a valve. Nobody killed or injured, but there was a release of a dangerous gas on a guilty plea with no previous convictions, £200,000. Selig UK Limited, a medium-sized business, failure to prevent access to moving parts. We regularly see cases coming before the courts where somebody has done something perhaps to unblock a machine, for example. They've come into contact with moving parts. The employer pleads guilty because although there's a manual explaining proper isolation procedures, the evidence is that in fact routinely people have taken a shortcut in accessing the machine to clear the blockage. This is one of those cases. I did a case almost identical to this before the regime came in. We were fined £12,500. Selig UK, say almost identical case, £240,000 on a guilty plea. ConocoPhillips had 3 hydrocarbon gas releases, different events that occurred, nobody killed or injured, but the prosecutor very specifically told the court 66 lives were at risk. So no need to consider whether the judge was motivated to push them up a number in his assessment of risk of harm. Very easy one there. And on a guilty plea, a fine of £3 million, which you might have thought would traditionally be reserved for cases of absolute tragic outcome in terms of death and injury. But the trend is obvious. I could put 20 times that number of cases up in front of you to show you the trend, but it will be obvious. The obvious points to summarise, to bring those points together, are these. This definitive guideline has introduced society's expectation of much higher penalties for large and very large organisations. There's not a huge amount of change at the lower end of the scale, but there is some change, but the real change is at the upper end. So if your turnover is in the tens of millions of pounds upwards, then definitely the numbers are much higher than they used to be. Another observation is there's much less focus on the actual outcome. It's all about potential. which ties in obviously with your theme of today of looking at what could be. And that's going to be very much what the court has to do, to look at and punish you for what could have been, to try to motivate more leadership and commitment to removing unnecessary risk in any industry. And finally, in terms of conclusions, the duration and the extent of the risk are key factors. You don't need to wait for the HSE to come in to think about these points and go and have a look at how you're doing. Could you demonstrate day-to-day compliance on your activities? But those are the things that would really be very significant in future in determining the level of penalty. The guideline also talks about individuals. I'll just give you the key headline there, which is that the word custody appears in almost every box that you look at. It's the same approach to assessing culpability, assessing risk of harm, then looking at whether you go up a number because of exposure of multiple people and the actual outcome. And custody just appears all over the place in the schedule. So the headline is, I suppose, if we build more prisons, there's a much increased risk of custodial sentences. But judges will be, I think, very cautious to send generally honest, hard-working people to prison who have let themselves down in respect of something. I don't want to scaremonger and suggest that prison is going to become the norm. I think it will still be reserved for the worst cases. I want to just finish by highlighting some areas that are really prone to non-compliance. Things that just regularly go wrong in large, good organisations that get them before the courts on a regular basis, and where the HSE may be very tempted to bring proceedings. Firstly, the job of appointing and promoting people. Often when we're working in an environment of austerity, when we're having to replace people at speed, when we're suddenly taking on new contracts, we might have a whole set of HR procedures as to how we normally approach assessing people's competence for the role, training them for the new responsibilities, and then it all goes out of the window when we're doing it under pressure. And as leaders, you really should be asking yourselves whether it's foreseeable in given situations that shortcuts will occur and people will be put into new roles with new responsibilities without being really equipped with the tools to do the job and without proper supervision around them to see that they're doing what they should be doing. We often find cases where somebody makes a mistake in the job and then it becomes clear that they were never actually given the proper tools to do the job in the first place. Quality of risk assessment, you've heard a little bit about that already today. So often we see cases brought before the court where the person doing the risk assessment, for example, had never actually done the job. There wasn't engagement with those that do the job to make sure that the safe system of work identified via risk assessment was actually the way the guys were doing the job. Or, for example, with electronic permit to work systems, for example, we've seen cases where there's a weakness in the design because you can do a copy and paste permit and so therefore bypassing the risk assessment process. So that's an area, I think, for opportunities for leadership. Quality of training and briefings, really ensuring that people know what you expect of them. You give them an intranet system with 600 procedures or more on. You give them a manual that's this thick, but you don't give them a month off work to read it. You don't test them on it. You don't actually necessarily make sure that they understand the regime that applies to the different activities that they do. And so what we often find is people are doing a job a particular way. They're doing it for a long time that way, but that's not the way your procedure says. And they just didn't realise it, and it hasn't been picked up in a robust auditing regime. In terms of inspection regimes, whether we're talking about auditing, whether we're talking about daily checks that things are as they should be, precautions should be in place, time and time again we see cases coming before the courts where the judge says, you weren't doing it properly. It had become a tick box exercise. You were just glancing at whether things appeared to be as they should be, but the quality of the exercise, the depth of the check wasn't good enough. Or the checks were okay, but people weren't then routinely acting upon the findings. You just weren't doing it well enough. We see that all the time in front of the courts. Introduction of new procedures is an area where there is so much guidance about what is expected of you, certainly from my world, the legal system, in public inquiries that there have been. It's absolutely clear that when you introduce a new procedure, it is a two-way process. You should be engaging with your managers about what you expect them to do with this new requirement. You need to ensure that they've engaged with the workforce and it's a doable requirement. And then you need to make sure that it has in fact been embedded and there is evidence coming back to you as a leader that things have been implemented as they should have been. Because what we tend to find is it's a one-way communication. Thou shalt do this from today onwards, and then it sits in an in tray, it's partially implemented, not fully, and then it becomes clear that the leadership at the top have not completed the loop. And finally, but the one that seems to cross my desk, 9 out of 10 cases that I see tend to be what I call local enforcement of the rules. So you have a manager, a supervisor, team leader, whatever the title is, somebody who is in fact expected, certainly in legal terms, to be the enforcer, to make sure that what you say you're going to do is what in fact you're doing. But in fact, the reality is those supervisors, team leaders, managers will often view their job as being to get the job done on time, to hit the targets, to keep those above happy with production levels. And they don't see themselves as having the responsibility of delivering the task the way it was planned. And so we see a failure at the local level to enforce all the good work that's gone before to establish a safe system of work. And things happen, things change, and the guy who's managing it is concentrating on production, and so they just carry on. That tends to be what I see most of. So all the good planning is there, but it then falls down locally. So that's it from me. I hope that's it's a bit of a race through of the new definitive guideline. You can see the messages coming from it. There's plenty as leaders to be thinking about and concentrating on. That's just a few examples. But otherwise, thank you very much indeed for the invitation to participate today. Thank you.